Number 41, the people of the state of New York versus Joseph Schneider. We'll take one moment, counsel, to allow your colleagues to move to the back.
Can I give my co-counsel a hand?
Yeah, that would be good.
You left something.
There's a
Counselor?
piece of paper
Counselor.
on the floor that
just-
may have fallen out of your
That
bag.
may be the key to the whole case sitting right
That's
there.
right.
Good afternoon, counsel.
Good afternoon. May it please the court, my name is Stephen Preziosi, and I represent the appellant Joseph Schneider. Your Honor, may I request 2 minutes rebuttal time?
Of course.
Your Honors, no New York court has ever held that a phone call with a point of origin and a point of reception outside the state of New York could be legally monitored under New York's eavesdropping laws.
What about a nexus to New York?
Not even that. I haven't found that, Your Honor. I haven't seen that. Where the phone call, Your Honor, is saying where the phone call is coming from outside the state to inside the state.
Right, maybe there's not a specific case, but I mean, isn't that something that would be relevant here in terms of interpreting the statute and whether it's permissible?
Yes, Your Honor. In fact, other states, I haven't seen a New York state that has held that, Your Honor. Other states have. Recently, there's the Nebraska case that I cited. There was phone calls coming from Texas to inside the state. Most importantly, Judge, we didn't have that in this case. The facts of this case were all of the phone calls were point of origin to point of reception outside the state of New York.
No, I understand that, but we're talking about a criminal enterprise that has a nexus to New York, as a matter of fact, to Kings County, right? Or at least that's what the affidavit in support of the warrant alleged.
The facts in the affidavits don't show that Joseph Schneider had any connection to New York, whether through a criminal enterprise or not through a criminal enterprise. He had no contact directly or indirectly with the state of New York.
Let's say he did. It's a cell phone, it's registered in Tampa, let's say, but you know, cell phone numbers travel now. So he's in New York, he makes a call, they go up on a wiretap, they're intercepting in Kings, he goes to Pennsylvania and makes a call to, you know, Washington, D.C. They can't now intercept that call in Kings County.
If there's some nexus to New York, Your Honor, there's some criminal nexus to New York, then
But the crime is in New York, like it's a drug conspiracy, so there's importation into Kings County, New York. But I'm having trouble understanding how your rule would ever work in the era of cell phones. Because point to point, the phone's moving. So the point to point, when you go up on the wiretap, may be Rochester or Greenpoint or wherever, but then the phone moves across the river into New Jersey. So now the wiretap is no good.
Your Honor, I don't see any support or any case law or anything in the statute that says outside the state. I understand what Your Honor's question and concern is. However, I don't see anything in the statutes that say or can be interpreted as point of origin outside the state to inside the state.
Well, is there anything in the statute that would preclude that? I mean, aren't we really looking at what it means to execute a warrant? Isn't
Yes.
Okay, all right. So is there anything in how that's described in Article 700 that would preclude it from meaning that its interception is what execution is, and if it's intercepted in New York, then that would be a valid warrant?
Your Honor, two things. One, the way we define telephonic communications. And because our statute in New York is modeled after the federal statute, we kind of have to juxtapose those two. The federal statute is 2510 sub 1, 18 U.S.C. 2510 sub 1. They call them wire communications. And our statute, the penal law, section 250 sub 3, is imported into the eavesdropping law. 250 sub 3 excises the language concerning interstate communications and communications that affect interstate or foreign commerce. That's deliberately taken
I
out.
have a problem with that argument, though. I thought that 2516 sub 2 would allow for an eavesdropping warrant for gambling.
25
You're relying on 1, but
Well-
on 2...
Well,
go
here's the
ahead.
distinction, Your Honor. The definition section is 2510 sub 1. Your Honor is referring to the enabling statute. The enabling statute under Title III for federal judges is 2516 sub 1.
So assuming that's the model, and it specifically mentions gambling, it seems to the express statutory language is directly contrary to what you're arguing.
No, I think gambling is mentioned in 25 sub 2, the enabling statute for state judges. However, the way New York penal law imported into Article 700 defines telephonic communications, comparing it to the federal statute after which it was modeled. The federal statute says, specifically, Judge, it was a long statute, I didn't memorize it. The federal statute says,
Don't read the whole statute, just tell me your point, that's okay.
the federal statute says telephonic communications include interstate communications and communications that affect interstate and foreign commerce. New York has taken that language out of the statute, out of our definition of telephonic communications. And what I referred to in my brief, Your Honor...
But doesn't that just refer to the fact that the federal government has power to do things only if the Commerce Clause is implicated?
It's Judge Wilson.
Right.
Oh, Judge Wilson.
Isn't the reason that that language exists in the federal statute because the federal statute needs to use its Commerce Clause power, and that's just a reference to that? The state doesn't need the Commerce Clause power? Isn't that all that's happening?
What it is a reference to is the enabling statute. Under 2516 sub 1, federal judges both expressly and inferentially have the authority to set up eavesdropping orders that cross state borders. There's
Sure,
the language
as long
as
as the Commerce Clause power is implicated, right?
Correct.
If it didn't affect interstate
the enabling
commerce, they couldn't do
statute,
it.
all of Title III stems from the Commerce Clause. Yes,
Right.
Your Honor, absolutely.
Right, and the state
So-
government doesn't depend on the Commerce Clause in the federal Constitution, right?
No, it does not.
Okay.
It does not. And specifically, if you put
And
the two
that's why
sides...
the language was excised.
I'm sorry, Your Honor?
And that's why the language was excised, is because it's irrelevant to the state.
It was irrelevant, and I think both under the enabling statute in the federal Title III, 2516 sub 2, and both under our laws, the intention was to interpret our laws more restrictively than the federal statute, and then the New York State Legislature under People versus Galena and People versus Washington, when our statutes are modeled after the federal statute and we exclude language, we excise language, that was done intentionally by the legislature.
Okay,
ask
so
you about-
let me ask you something else, because I'm having a little bit of difficulty understanding how the statute applies with respect to cellular devices, in this case, cell phones. So, okay, is it an interception that occurs in New York or a redirection that brings the communication into New York? What occurred here, please?
Thank you, Your Honor. Yes.
I mean, these are not cell phones where you and I, let's just say, we're in New York and we're talking on our cell phones, correct?
Yes.
Right? These are cell communications happening outside the borders of New York State.
Correct.
And that communication is brought in.
Correct.
Okay?
So, Your Honor, from the Seminole case, the Rodriguez case from the Second Circuit,
Yeah.
the big holding was redirection presupposes interception. So my argument is simply this. When Joseph Schneider picked up his phone in Los Angeles County, California, his voice, the human voice, was transformed into a digital signal. At that moment, the signal was redirected, was captured, split,
And who redirected it?
by the order of the warrant of the judge sitting in Brooklyn.
But who could actually redirect
The
it?
phone company.
Thank you.
The phone company.
Okay.
So The signal was redirected in Los Angeles County, California. At that moment, it was captured by the effect of the order of the lower court in Brooklyn. At that moment, the Brooklyn District Attorney had control over that signal.
So yeah, let me ask you a different one.
And that is where the interception occurred.
From your point of this argument, and I know you're going to disagree, but I just want to understand. I think they're arguing that a justice in New York or judge in New York has authority to order that redirection outside the borders of New York to bring it in. So what's your argument why they cannot do that?
My argument is because the express language does not appear anywhere in Article 700. There is absolutely no language with regards to interstate communications. We, in fact, exclude from our definition of telephonic communications anything having to do with interstate communications or communications affecting interstate commerce. Comparing the enabling, going back to the enabling statute, and I think that's where any analysis of this has to start, because federal judges under 2516 sub 1 expressly and inferentially have the power to cross state borders. That language is absent in the enabling statute, and it is absent in our statute as well. And if you look at specifically the statute that we're talking about here, Your Honor, we're talking about 700.05 sub 4.
But counsel, I have a, up here.
Judge Garcia.
I'm sorry if I might, Chief Judge. I think the light's on.
Yes,
please. I'm having some trouble understanding again how this would work, and maybe I just don't understand the technology. So, cell phone in California makes a call, let's say to Utah. By order, wiretap order, that signal gets redirected to New York where it is intercepted by law enforcement in Kings County, right?
Yes.
No order, phone call gets made. The signal, I presume, would somehow go right from California to Utah.
Yes, Your Honor, and just so the court knows, there's an excellent explanation of the technology.
But before we get to the excellent explanation, so let's say I'm in New York, I'm in New Jersey, I make a call, I'm calling Canada, but the signal's going to go through and be routed normally through upstate New York, Rochester, let's say. So a judge in Rochester, because the signal's not being redirected, could issue the warrant. Is that the kind of system we want?
No, Judge, I think when the force of the warrant in this case redirected the signal from California.
But I guess what I'm getting at is what's your rule that you want us to apply for people getting wiretaps in the future? Can the Rochester judge order the interception of or execution of a warrant in Rochester because the signal is naturally passing through Rochester?
No.
Or do you have to examine, so we would have to examine point-to-point calls and where they go through and if they are being redirected into the jurisdiction?
Judge, just in terms of the technology, they can be redirected from anywhere. This is the new technology of the...
But to follow up on Judge Garcia's point, isn't this basic determination, first off, if any judge in New York issues a warrant, it's good for the whole state, right?
Yes.
Okay. So the judge makes a probable cause determination to get an eavesdropping warrant, that turns on the elements of the New York crimes. That's the key point here. Not on the elements of California crimes, or in this case, I think it went from California to New Jersey, right?
Yes.
So California, New Jersey crimes. So why wouldn't a New York judge be able to look at a conversation about New York crimes?
Because Joseph Schneider didn't commit any crimes in New York.
Well, he pled to some. So I don't know.
But that doesn't, the facts of the affidavit must stand on their own, Judge.
Let me finish my point.
Regardless of his plea.
He apparently pled to some, so I don't know if you can argue that, and I don't think it's a main point. But the point I'm trying to make here is that the elements of the crime that is being alleged that are New York crimes are what are the basis for the probable cause determination that a judge has to make about an eavesdropping warrant. And that would apply for any state in the union. It seems it would be consistent and not a violation of any federalist principle.
Well, Judge, what I'm asking is what has historically always happened.
Sure, go ahead.
The execution of warrants has always been local, always.
But we didn't have cell phones historically.
For example.
Well, but we're dealing with a different animal here.
And the
that's what we're trying
execution,
to ascertain what the rule should be.
the execution of this warrant occurred in Los Angeles, California, when they captured and redirected that signal.
When who
It is nothing-
captured and redirected that signal?
I'm sorry, Your Honor?
You mean when the law enforcement officers in Kings County captured it there?
Yes. That is where the effect of the warrant took place, in
Okay.
Los Angeles.
So
And it is,
let me take maybe Judge Garcia's question a little bit further. So that means that every time a call is intercepted, that the warrant has to come from where that phone is at that minute. So 1 minute, the car is in New York State, and then the next minute it crosses the bridge and it's in New Jersey. And if you don't intercept it at the right time, too bad.
no, I don't think that's what it means,
Is that the
Judge.
rule?
No.
Okay.
I
so
think
what
if there's
is-
some criminal nexus to New York, then there is support in other states' case laws, not in New York State, but in other states' case laws, interpreting their statutes. However, those are not the facts of this case. Joseph Schneider never moved from California. And what I'm advocating is this, where this
Well, so you're
wiretap,
assuming that the nexus has to be the physical presence of the person? There
No.
can't be a nexus to a crime
but he or
without
she
that?
has to be committing a crime in New York. There must be
Well-
some criminal nexus to the state of New York.
Okay.
And what I'm advocating is this. Execution, where the term that seems to be kicking up all the dust here is where was it executed? Where was the warrant executed? The warrant was executed where they took control of that signal in California. And this wiretap operation went on for a couple of years.
Is it fair
They-
to say
they could
that this rule is simply, what the people are arguing for is a listening post rule?
Yes. And here's why the listening post rule violates both the enabling statute and New York state law.
Sure.
The enabling, when we say that the warrant was executed at the point of the listening post, it puts state judges on equal footing with federal judges. And that is not what the enabling statute, 2516 sub 1 and 2, had envisioned, that giving state judges that authority. The statute, Title III of the statute, was envisioned that states would adopt more restrictive laws than the federal statute. And we did that. We
So
did that
if
when
New
we
York
defined
judges can't-
telephonic...
Let me ask you this. If New York judges can't do that, that's your position,
Yes.
do investigators who are investigating a crime, a New York crime, have other tools under the law in New York to try and get the evidence that supports a prosecution?
Absolutely.
Okay,
Absolutely.
what would that be?
State investigators collaborate with federal investigators every day. Many federal agencies have liaisons in state law enforcement offices. The federal courthouse is a block away from my colleague's office at the Brooklyn DA's
Let's say the
office.
feds are not interested. What other option is available?
They can go to Los Angeles and seek a Los Angeles County judge's order, as they did with the arrest warrant and the search warrant. And Judge Stein, this comes back to the issue that Your Honor was raising. The execution of warrants, the term execution, has historically been local. For example, when New York law enforcement goes to a sister state to execute an arrest warrant or a search warrant, they must go before a local judge and conform and comply with local law.
Well, I guess...
The same thing, we require the same thing here in New York.
I understand that argument. I'm having difficulty understanding how it applies to cell phone communications, because certainly, even in this case, sure, they physically went to California to arrest the defendant with the cooperation of the California authorities, right? But that doesn't answer the vexing questions we have about
And let me
what
try
we
to do
about
that, Judge. Let me try to do that.
self-communication.
Because this investigation went on for over a year, they could have gone to Los Angeles and sought an eavesdropping warrant from a California judge. They didn't.
They could have, and maybe in this case they could have, that's right.
But- and
in
here's
other
why-
cases, when you have somebody traveling around, moving around, crossing state borders, whatever.
Did not happen here.
I know, but if we make a rule...
Does that mean in a multi-jurisdictional narcotics investigation that if there are 50 people involved in the conspiracy that's happening out of New York City or Brooklyn, as here, that they'd have to travel to every one of those jurisdictions to
No.
intercept all those co-conspirators?
No, Your Honor. They
What does that
can
mean?
collaborate with federal authorities, and they do that every day. Nothing overburdensome, nothing new. Judge, and here, I just want to come back to this. Because if we allow a New York State judge, and the conversations being heard here, the majority of conversations were California to California. But the conversations span the entire continental United States here. And here's why I think this is such an egregious abuse of discretion from this judge sitting in Brooklyn, because the conversations were the entire continental United States and beyond.
But counsel, I'm sorry, but it seems to me you want to equate execute, which we keep coming back to in the statute, to a call-by-call execution. Like, where are they redirecting that call? Because let's say the phone's here, it's a mobile phone, they make a call out of Brooklyn, and then they go to California. I execute that warrant first in Brooklyn, and I intercept that call. Then the target goes to California for the next year. So I can only capture the first call because I'm executing the warrant on the thousands of other calls in California?
Well, Judge, here's the support for my...
But is that the rule that you would have, that execute means you look at a call-by-call basis?
No.
So which one do we use for
Certainly
execute?
there could be exceptions for
No,
a
but
traveling cell phone.
what do we define execute as under your theory?
When they took control of the digital signal in Los
For the
Angeles.
first call or for the 1,000 calls?
That's all his calls. All of his calls.
But let's say it's not all of his calls. Let's say he makes 3 out of the 1,000 calls in New York. So execute for those 3 calls would be in New York?
Well, he didn't make any phone calls to New York.
Hypothetical.
So if he's calling from California to New York, Your Honor?
Or the other way, he makes 2 calls from New York and then he moves to California for a year and makes all the rest of his calls in California.
And Judge, there would have to be some criminal nexus back to New York. We would have, I mean, and these cases are so fact-specific, Your Honor.
Execute. I'm trying to understand what your definition of execute is, because I go in, I get the warrant, the judge can sign where the warrant is executed, right? So I need to know that now. So what am I telling the judge executed means?
In this case, on these facts, Your Honor, all of the cases, all of the federal cases say execute means at both the situs of the phone and at the listening post for the federal cases. And here's why I say that violates the law.
So
when they
I
say,
get why that's not the rule here, but what is your rule, why you believe that's not the rule, what is your rule for the judge sitting in Kings County for execute?
my rule is both, at the situs of the phone and at the listening post, but not for New York. New York cannot say just the listening post. And here's why, Your Honor, because under federal law, execute means situs of the phone and the listening post. Situs of the phone is fine, because then under federal,
So then when I'm
judge.
listening to the phone calls and I realize a call is California to Utah, even if it's being intercepted in Kings, I minimize that call, or just the warrant's no good?
I think all the evidence should be suppressible, Your Honor.
The entire, even the New York calls?
And here's why, Your Honor. If we say, as the people are advocating, that the interception only occurs at the listening post, that puts New York judges on the same footing as federal judges, which the enabling statute never intended. And it allows New York judges to violate sister state laws, as it did in this case, because California requires that a sister state must have a joint investigation with their law enforcement in order to intercept California phones. So if you've put the point of interception at the listening post, and then you're starting to run into the separate sovereign doctrines and, you know, the full...
Counsel, if I could just interrupt here for a second. When I read your constitutional arguments, I sort of got the feeling of, you know, federal constitutional spaghetti against the wall. Can you tell us what you think your strongest constitutional argument is here?
I think it's the full faith and credit clause, Your Honor. And here's why. The full faith and credit clause says we must give the same preclusive effect to evidence coming in that was obtained in California here in our courts. In California, the wiretaps were illegal. Why? Because one, they don't allow eavesdropping on gambling offenses.
But doesn't
and two,
that presume that we have competing proceedings going on in the different states? Isn't that what full faith and credit
We have
is
conflicts
about?
of law. That's what the full faith and credit clause was
Okay,
intended
but we
to
don't
do,
have
to
that
harmonize.
here. They're not doing any litigation over this in California.
No, it was never brought into California court.
Okay.
This was never
Because
brought
they
into a
can't
California
be,
court.
right? They
And
can't.
and this is why, going back to Judge Garcia's question, is if we put, as the people advocate, the point of interception, the point of execution of the warrant at only the listening post, then it allows other sister states, as New York did here, to go into California and violate California law. And we can say, hey, we're not intercepting your phone calls of your citizens because we define intercept and execute differently. And that's not okay.
Counsel, does the listening post rule
Sorry, these masks, sorry. Sorry.
support the strong public policy concerns that form the foundation of the notion that the supervising judge of the wiretap has to be hyper attuned to minimization issues and privacy issues? Isn't that part of this also in these big multi-jurisdictional investigations, to have one judge overseeing and supervising the entire eavesdropping investigation?
You know, Judge, I think it cuts both ways. And what's interesting, Your Honor's question brings us right back to the seminal case of United States versus Rodriguez. In that case, Judge Meskel wrote a concurring opinion that kind of read more like a dissent. And he complained about the majority's opinion, saying, you know, that this one supervising judge rule sometimes has a good effect, but is one judge supervising, as in this case, conversations that take place across the continental United States, is he as concerned about what's going on in those conversations from Hawaii to California as a local judge, as much as a local judge would have been? So I think, Your Honor, to answer your question, it cuts both ways. Would it be more organized for a prosecutor to have one judge? Certainly, yes. Would the a judge sitting in Brooklyn be as concerned and as vigilant about looking at conversations occurring in Hawaii and California? I don't think so. So to answer Your Honor's question, yes
Well, if you
and
were
no.
assuming that the judge's interest was solely local crime and protecting against local crime and not about
in that
being
case,
mindful of minimization rules and...
In that case, yes, no, Your Honor, if it was just the local crime. But I think there were so many conversations here that had nothing to do with New York, that did not touch New York, California and Hawaii. Most of the conversations were California to California. Judge, I think I've taken way too much
Yes,
time.
thank you, counsel. You'll have your rebuttal time. Counsel?
Good afternoon, Your Honors. May it please the Court. My name is Morgan Dennehy. I represent the Kings County District Attorney's Office, who's the respondent in this case. I'd like to begin just by clearing up just a repeated misstatement by my opponent, claiming that his client, there was no evidence in the search warrant applications that his client was committing crimes in Kings County. That's false. In the appendix submitted by the appellant are the search warrant applications. And I point out in page 32 of my brief the various pages of those applications that allege criminal conduct by the defendant.
Well, that may be true. The question is whether or not you could get this particular kind of warrant to be able to overhear these communications. I just want to be clear on your rule. This is my hypothetical. I want to know if under your rule, a judge or justice in New York could order the eavesdropping warrant. People calling each other on cell phones in California, talking to each other. One is in San Diego, one is in San Francisco.
Yes.
Talking on their cell phone. Can a New York judge, and let's say they're talking about committing a crime in New York. Fine. Can a New York judge order a wiretap on these cell phones?
Absolutely, Judge. The location of the callers is irrelevant in this analysis.
Well, what's tell me where the authority is in the statute to cross the state's borders to do that.
Absolutely. So the jurisdiction, there's a clear roadmap here. This is a case of statutory interpretation, and it's right here in the statute. So we could all agree that the word execution is paramount here, because so long as the warrant is executed in the judicial district in which the justice resides, that justice has jurisdiction. So the question before the court is, what does the term execute mean? And the statute provides an answer. While there's no, it would be convenient if it was in the definitional section of the statute, it's not. But there's other sections of CPL Article 700 that talk about the term execute, that uses that term in
just
context.
tell me the provisions. Go ahead.
I'm sorry, Judge?
What are the provisions exactly? Where are you?
Right, so we start with 7035 sub 1, and that says that it's the manner and time of execution of the warrant, and that requires that the warrant must be executed according to its terms by a member of law enforcement. So we start with the proposition that law enforcement executes these warrants. Then you go to...
Still doesn't tell me that, you're not arguing that the law enforcement officer can cross the state borders, are you?
No, absolutely not, Judge. That's the first step. So
acting within the state borders. Go ahead.
acting within the state borders, correct.
Right.
And then form and content, 700.30 sub 7. The eavesdropping warrant must contain a provision that the authorization to intercept shall be executed as soon as practicable. So we're talking about interception now. So law enforcement, interception. And the term executing being used with both
So let me
ideas.
ask you, what's the difference between redirection and interception? If any, from your, according to your interpretation of the statute?
Right, so the phone company is not intercepting anything. They have the signal. Law enforcement is making the interception, because when the redirection occurs, that's when the interception occurs.
So there is a redirection? When it's not a call.
The interception happens after the redirection, Your Honor. Because talking
So
about...
the interception cannot occur without a redirection?
That's right. The redirection is necessary to the, it's the step...
Let me ask you something else apropos of some questions that were asked to the defendant's counsel about what happens when, you know, someone with a cell phone, either the call itself is crossing state lines or they themselves move across state lines. So you can correct me if I'm misunderstanding the CPL. CPL 700.054, that's the definitional section, does have at the end of that provision a discussion about conversations in a car and a car phone. And it says at the end that you execute and intercept in the state.
That's
Now,
right, Judge.
Of course, a car phone could easily cross state lines. We have the same problem as we do with cell phones. Why doesn't this tell us that the legislative intent is that a judge's order cannot allow for crossing the border?
The answer, Judge, is because the term execute doesn't contemplate the location of the caller. So if that car crosses state lines, it's irrelevant, because the execution is still occurring when the law enforcement officers are intercepting and overhearing the calls. That language that Your Honor has highlighted, relevant to cellular phones affixed to cars, actually expands a justice's jurisdiction. You don't have to intercept and overhear the communications in the judicial district in which the justice sits. You can do that in the entire state. But again, it's not a restriction on jurisdiction.
But it's still the entire state. That's what I'm not understanding about your argument. With respect, I think there's a lot of tension and uncertainty with respect to the statute. At the end of the day, it may very well be that, given the last amendment is not even in the century to this statute, that perhaps the legislature needs to step in and address this very serious concern that we've all been talking about today. What do you do in this kind of crossing border?
I would respectfully argue that it's plain from the reading of the statute, Judge, and also common sense. When's a warrant executed? Let's talk about a traditional search warrant. It's executed when the authorities go to the location and they go in and seize evidence. That's the execution of the warrant. Here...
Right, when they go in and search, right?
That's right.
And if they find something pursuant to the warrant, they do that.
That's the
Right?
execution.
So when
That's
you
the commonly known
you have
term.
not done that because you haven't heard anything.
Right. So the taking of evidence here is the hearing of the telephone call. So just as common
So you're
sense...
saying it's the final stage, not any preparatory stage.
The machinations of getting the signal to the listening post is not the execution of the warrant under the terms of the statute.
Well,
The terms of the statute are pretty clear. It's when law enforcement overhears and intercepts.
By analogy to a conventional search warrant, you wouldn't have a warrant authorizing a direction to a private party to go out of state to bring physical evidence into the state so it could be viewed by police in the state, right? That wouldn't work.
It's not permitted in the search warrant statute,
So
Judge.
let me switch you for a moment over to the federal statutes, and particularly to section 2518. So 2518.3 has a provision in it that is specific to federal judges that authorizes the use outside of the territorial jurisdiction where the federal judge is sitting in the case of a mobile interception device.
Yes, Judge. That, again,
there's no definition of mobile interception device in the statute that I can find.
Right, so
And
the
it
federal
looks to me-
statute is
just
allowed.
let me finish. It looks to me as if there is a circuit split between the 7th and the 10th circuits about what that means, with the 7th Circuit taking the position that it actually doesn't mean the device itself, it's meant to reference cellular communications. So there's no similar provision regarding state judges in the federal statute. What do we make of that?
That no way limits a state court's jurisdiction to issue a warrant so long as the calls are overheard and intercepted in the jurisdiction of the court, in the judicial district of the court. Just as the federal statute is pretty much the same as the state statute in that the location of the callers is not the focus of the jurisdiction. It's where the calls are intercepted. And that mobile listening device provision expands a federal judge's jurisdiction beyond their judicial district when a mobile listening device is used. So again, they're not talking about where these callers are. They're talking about where the listening post is set up. So just as the extra language in the New York statute about the mobile devices that fix the cars expands the jurisdiction to the whole state, this federal language expands the jurisdiction beyond the federal, the judicial district that the federal judge sits, to other areas where the mobile listening device is. Again, the fact that language exists...
That's the 10th Circuit's interpretation.
I'm sorry?
That's the 10th Circuit's interpretation, but not the 7th.
Right. So I'm not familiar with the distinction Your Honor is drawing and what impact that has on a restriction on it.
Well, let me ask you this. Is it your view that the federal statute essentially provides the authority for states to act so that states can't act in a way that is inconsistent with what's set out in the federal law?
That's correct, Judge.
Okay.
But the state statute does not exceed the bounds permitted by federal law. It's on point with the federal law. It was modeled after the federal law. And if Your Honors would look at every single case that has addressed this point of where this jurisdictional issue, both federal and other states, this is a case of first impression for New York appellate courts, but two lower courts in New York have addressed this issue. The term executed means when the law enforcement officers overhear and intercept these phone calls, and so long as that's done in the judicial district in which the judge issuing the eavesdropping warrant sits, jurisdiction exists and the warrants are properly issued. I cite all the cases in my brief. There's a whole host of...
So your whole argument turns on the interception occurs at the time that the officers listen to the communication. Is that correct?
That's correct, Judge. That's what all these cases hold. I'm not making this up, and it's also based on a plain reading of the statute.
So then what are we to make, if anything, right, of the fact that the only way an officer can listen is if indeed we're crossing state borders, in this example, right, the calls that are made in California, not New York, not to or from New York, or at least one person in New York, to bring that communication in.
Yeah, that doesn't affect the court's jurisdiction,
Okay,
Judge.
but why not? That's what I keep asking.
Right. So again, I would point, Your Honor, to the statute that the term execute, and the term execute means the overhearing and listening of the conversations. So long as that's done in the judicial district of the judge, then you have jurisdiction and the warrants are properly issued. How those calls get there is not, it's insignificant detail with regard to how the statute is written.
Counselor, how do you respond to your adversary's solution to all of this is that the local law enforcement officials simply have to cooperate with the federal law enforcement?
Well, I think it's ridiculous.
No, I mean, what's the practical?
First of all, there's no requirement. The way the statute is written, it certainly enables us to go out and get these warrants. And to say that, that's a viable alternative it's not feasible. Sometimes we're prosecuting crime. Sometimes the feds maybe aren't interested in the crime we're interested in. Maybe they don't want to help us. They don't have the resources to help us. And then we would have to let criminal activity go.
Well, more fundamentally, isn't it usually because the crimes that you're pursuing are not, there's not a federal equivalent. You're pursuing a New York crime that's being committed based on in New York State with communications that arise outside the state.
Yes, Judge, that as well.
So the federal government would need a federal crime
Yeah.
predicate to go up on a wiretap federally.
Right.
But it may not be equivalent crime to something you're investigating in
That's
local.
right, and cases would fall through the cracks.
Thank you, counsel. Counsel,
Thank
your
you.
rebuttal, 2 minutes of rebuttal?
Judge Garcia and Judge Fahey, just let me address that last question. All of the crimes that are in the enabling statute under 2516 sub 1 for state judges are also in the enabling statute for federal judges, but not vice versa. So is it a crime in federal? If we have the ability to eavesdrop on it, it is also a federal crime, per force. And Judge Wilson, I wanted to address one of the topics you had raised. 2518 sub 3, that express language that I had referenced earlier, is contained in the federal enabling statute, but is completely absent in the enabling statute for state judges, and that is absent purposefully. In addition to that, it is absent purposely from our New York State's definition of telephonic communications. And Judge Rivera, I think Your Honor has hit upon the most important topic, is that perhaps it is time for our legislature to revise these statutes. But as they stand right now, we have a new technology that crosses borders, that allows phone calls to be redirected from anywhere to anywhere. That's new. Typically, our cases, historically, whenever we have come into a new technology, we have provided greater protection to the citizen. Going back to, Your Honors will remember the Katz case, where we had microphones on top of telephone booths. For the first time, we embraced the spoken word into our Fourth Amendment. Then more recently, we had Riley versus California, where the U.S. Supreme Court said, hey, listen, the cell phone is a new technology. It needs greater protection. Normally, when you arrest somebody, you have the right to search all their possessions. But a cell phone needs greater protection because of its uniqueness and all the information that it possesses. We provided greater protection to the citizen. Even more recently, we had the Carpenter versus the United States with regards to cell site location information. For the first time ever, we gave a defendant standing when information was in the possession of a third party. So whenever we have run into these new technologies, we have typically provided greater protection to the citizens under the Fourth Amendment. And that is what I'm asking here, Your Honor.
Thank you, counsel.